Good afternoon. My name is James Apostolos, and I'm the Director of Education, Events, and Membership here at NASAA. I'm very pleased that you have joined us today. I would like to welcome you to our special webcast, NASAA's Senior Issues and Diminished Capacity Committee presents Financial Services Industry Experts Speak. Before we get started, I have a few housekeeping items to run through. First of all, please note that this meeting and webcast is being recorded. Second, please note that the views expressed by our speakers and panelists on this webcast are their own and do not necessarily represent the views of NASAA, their agencies, or organizations, unless specifically so stated. Next, if your state or province allows you to self-file for continuing education credits, we have provided you the documentation to do so. At some point during the webcast, you will see a verification code placed on the screen that you will use to verify your attendance. We will only show the code once, so it's important that you write it down. You will need to enter this verification code into the appropriate spot on NASAA Learning to receive your certificate of attendance. You will find all of the CLE information that you need in the Continuing Education tab on NASAA Learning. It is now my pleasure to welcome NASAA's President and Maryland Security Commissioner, Melanie Center-Lubin, who will deliver our welcoming remarks. Welcome to our program, President Lubin, and thank you for joining us.
Thanks, James. Good afternoon. On behalf of NASAA and its Senior Issues and Diminished Capacity Committee, welcome to today's NASAA Presents program. My name is Melanie Lubin, and I am NASAA's President and Maryland Securities Commissioner. I have the privilege this year of leading this great association of securities regulators in the states, the provinces, and the country of Mexico as we work together to educate investors and protect them from fraud and abuse. First, I want to thank the outstanding efforts of NASAA's Seniors Issues and Diminished Capacity Committee for bringing this important topic to a wide audience. Thanks also to the NASAA corporate office team for their work in coordinating the logistics of today's webinar. Today's program strikes at the very core of NASAA's mission, protecting investors, and it highlights the work of regulators and the efforts of the industry to protect older investors in cases of suspected financial exploitation. We know that our work to mitigate the exploitation of vulnerable investors requires coordination and collaboration among many stakeholders. Today, we are featuring guests from the financial services industry. These experienced industry professionals represent firms employing from 2,000 to almost 20,000 registered brokers or agents in distinct business models. We will focus on the important but not necessarily easy work within the investment industry to prevent elder financial abuse. I know from my own work in this space that it is exhausting, difficult, and at times heartbreaking, but also is some of the most important work that we do. Gaining insight from a variety of stakeholders into what works and what does not work to prevent harm to vulnerable investors will help us navigate these problems in our own work and in our families. You are getting an opportunity to understand what it feels like to be in the trenches, where the wrongdoing by bad actors intersects with money losses from brokerage and bank accounts. NASAA, through this program and other initiatives, believes it is critical to amplify the voices of those devoted to the cause. By working together, we can develop and share best practices to protect investors who truly need our help. Thank you for joining us today, and I will now turn this over to our host for today's program, NASAA's Senior Issues and Diminished Capacity Chair and New Jersey Bureau of Securities Enforcement Division Chief, Richard Such. Rich.
Thanks so much, Melanie, for your leadership in that kind introduction. On behalf of my fellow Senior Issues and Diminished Capacity Committee members, and from me, I send a warm welcome to all of the people out there tuning in for this conversation. In our work here, we protect investors who, because of their vulnerability, cannot or do not make sound investment decisions. Vulnerable investor exploitation has a direct cost to investors estimated to be at least in the tens of billions of dollars annually. The societal cost, what it costs the government and the victims' families who are dealing with this tidal wave of fraud, is a multiple of that enormous sum. Bad actors in this space take many shapes, from family members to caregivers to social media-based romance scammers and financial advisors. Today, we will be focused on how financial services firms design and operate programs to mitigate this fraud when vulnerability or exploitation are suspected. The good news is firms like the ones you will hear about today can and do mitigate harm. Through the lessons learned in the field, through process-driven actions, and through information sharing in venues like today's event, these firms and the stakeholders that they work with drive down incidence rates and create interventions to thwart bad actors seeking to take advantage of an investor's vulnerability. None of us who work in this space is deterred by the odds that we face, and NASAA is delighted to lead here in pursuit of its core mission to protect investors, particularly those who most need our protection due to vulnerability. So let's get started here. I'd like to first briefly introduce the guests on our first panel. We have Nancy Hefner from the Lincoln Investment Companies. She is the Director of Compliance. We have Ron Long, Wells Fargo Advisors, Director of Elder Client Initiatives. We have Heather Murphy from Commonwealth Financial Network. She's the Director and Deputy Chief AML Officer. We have Tom Mirswa, Morgan Stanley, Executive Director in the Branch Advisory Group of the Legal and Compliance Division. And finally, we have Debbie Norrie, who's suffering with a little bit of a cold, from Fidelity Investments, Senior Director of Elder Financial Investigations. I would point out that Nancy, Ron, and Maren Gibson, who you will hear from later, also serve on NASAA's Senior Issues Committee Advisory Council. Nancy, let's get started with you. You have about 2,000 registered agents at Lincoln. How did you put together your firm's system?
Well, thanks, Rich, for having me today. It sort of comes about as things occur at the firm, right? You start getting complaints and issues, and you start seeing patterns, and it sort of snowballs into, we need to have a process for this. And this is way before, any of the FINRA regulations or such have come into play. So I'm in compliance. And so a lot of these issues start there. And it's myself and a legal associate that work on these issues. And granted, it's not our full-time job, but we take each referral and treat them, as importantly as you would anything else, and work the case, so to speak.
So let's go to the other end of the spectrum. I'm sure there are people out there that sympathize with only having one or two people in the department. And let's face it, there are a ton of investment advisors out there, particularly the state-covered investment advisors, that are frequently one-person shops. So, Ron, let me turn to you. How many registered reps does Wells have nowadays?
Depending on the day, we're anywhere between 11 and 13,000.
Okay.
And so the way we would work the program is we centralize it with a team that based in St. Louis and partners with another team in Portland. So probably total about 35, 40 folks between the two teams that take the reports in, and then those that need a closer analysis, that work is done, maybe an interview with the financial advisor as manager or what have you. And then the report is filed with Adult Protective Services, and we'll talk more about reporting later, but it's that sort of centralized view where you don't want to have one-off in one region, which is better than another region, all coming into the central hub, taking care of all 50 states.
Deb, you're somewhere in between those two figures on registered agents at Fidelity. Basically the same setup, or how do you do it?
Yeah, so typically the same setup. We're such a large firm that fortunately we are able to have dedicated groups that handle the diminished capacity and senior issues. We get a lot of support from our legal team and our back offices. So we have very dedicated teams of up to 30 people that are handling our diminished capacity concerns and our investigations. So as a big firm, we are fortunate. We recognize that other firms, don't have that kind of volume or capacity to do so. I think it's important that everybody has some kind of escalation process and person to go to for these cases.
Heather, Commonwealth is on the smaller side, not small, but smaller. How many registered people are at Commonwealth?
We have just over 2,000 registered or duly registered advisors.
How is your system set up?
Similar to everyone's, we have a centralized group. So we have 2 full-time analysts who conduct the investigations and myself. And we also have a lot of support from in-house counsel, as well as we partner quite a bit with our compliance department, whether it's in, individuals that are conducting branch audits or that are taking incoming calls from our advisors. We get a lot of our referrals through compliance.
Tom, last but not least, what does it look like over at Morgan Stanley?
So the consistent theme is centralization. You need to have someone in charge of this. One group, wherever it resides, risk, compliance, legal, or AML. It could still be one central group. The size depends upon the size of the firm. It's an assessment you have to make given the volume. I mean, smaller matters, the one-hit matters take less focus, but there's some that carry on for a very long period of time, become very, very complex, both with the activities of the client who may be resistant to being assisted as they're being exploited, to other family members coming in and throwing themselves into the mix. But multidisciplinary composition is very important, whether they're part of the group or people to whom you can turn for assistance. So you need people from global financial crimes. You need people from security to help pursue funds once they've left. You need people from legal or risk to assess the legal or the risk ramification of decisions. And you also need, as Ron alluded to, somebody focused on reporting to make sure that your reporting is consistent across the board in those states that are mandatory and those states that are permissive. And separately, we haven't discussed is you need to have a good internal record keeping for many reasons. You want to make sure that no ball hits the ground. So you're tracking the matters that are out there. And you want to make sure as well that if you are challenged at some point in time, whether by a regulatory audit or by a litigation subpoena, you can demonstrate that the actions you've taken, and that they are a very reasonable and good faith response to what appears to be either future or current or past financial exploitation.
Thanks, Tom. I would add, particularly for the smaller firms, that we end up in New Jersey. We have a report and hold law, and we're going to talk more about reporting out to securities agencies and APS. But we try to help firms. Firms frequently just don't know exactly what to do, and we do. We take phone calls all the time about what next. All right, I'm going to pivot now to the segment that Deb called "Stopping the Bleeding," and this is when we know something bad is happening. We know we have a bad actor. We know money is at risk. So how would you kick us off on stopping the bleeding, Deb?
So, Rich, as you mentioned, billions of dollars are in losses to our seniors, and that's only reported cases, right? So oftentimes, because this is so difficult to detect, oftentimes there are already disbursements that have taken place right before the red flags are identified. So it's very important to stop the bleeding, right? And the number one reason is we know from experience that when the money is gone, the money's gone. Right. So technology has made our lives much more convenient, but it's also made it easier for financial crime. So money has moved so quickly across various platforms. You have ACH, you have Wire, you have peer-to-peer payments like Venmo and PayPal, and you have cryptocurrency. Oftentimes, money is moved internationally or to third parties and dispersed very quickly on the other end. So, even trying to recover some of these funds is unsuccessful, especially if, more time has gone by. So very important to stop the bleeding.
Yeah, I was talking to somebody in my unit today about something that happened in 2019 and talking to the lawyer for the person. And the money moved from the firm, a major firm, to a bank, and then ATM withdrawals over a period of time that made virtually no sense. And the person's older and frankly doesn't remember much of it. So once the money's gone, it's gone. What can be done to stop the bleeding in your judgment? What action can firms take with or without government intervention to stop the bleeding?
Right. So I think it's important that we talk a little bit about 2165, right? Because this was really critical for firms, where the rule initially, when it rolled out, was it gave firms a safe harbor to place a stop on a transaction if they believed elder financial exploitation was occurring. Right. So initially it was a 15-day hold with the potential to add 10 days. And more recently in March, there was an amendment to this rule where there was an additional 30 days added on, because it does take some time to perform, an investigation. Now, some firms, maybe even, larger firms like Fidelity, had something in place where maybe through a customer agreement where we were able to put a restriction on a distribution. So I think 2165 has been very important for firms that did not have that in place, allowing them a way to stop a transaction that they were suspicious of, perform an investigation, and find out, what is really going on.
Heather, what are you confronted with, and how do you try to clamp down? I mean, to Deb's point, the rules have been around. They've become more liberal. The FINRA rule states, it varies state to state. I personally have not seen a lot of sentiment by regulators to I'll say, toy with firms that are trying to lock down transactions for the right reason. If I had a choice, if I were at a firm, lock it down or not, because I was worried about regulators, I would lock it down 10 times out of 10. How does it work at Commonwealth?
Well, I would say we are on the side of caution. We would definitely want to lock an account down where we suspected there was exploitation, but it's almost a balancing act too, because you have, a client's needs, especially if it's a senior investor and they need a certain amount for income or their circumstances change. So striking that balance of, protecting their financial well-being, but at the same time, being open to alternatives if you need to pay a care facility directly, or in client needs monthly income.
Yeah,
so,
important point. You can only lock down the suspected exploitive transaction. You can't just summarily lock down everything, right, Ron?
Well, that's usually true, but again, if you are talking about protecting the senior, what you don't want to do is say, I lock this transaction down, and then you go and find that they've moved money in other ways. But yes, we want to focus on the transaction. And remember, the seniors, the biggest part to stopping the bleeding, as Heather hinted at, is the senior who says, who are you to tell me that the love of my life can't be in Belarus? Well, how do you know it's not a great business in Nigeria? So you put the firm in a tough position when we're saying, how do we slow these transactions down?
Nancy, anything to add on this?
Yeah, I would say also it's helpful to not only look at the transaction, like Debbie said, the one that's now raised a red flag, but also look at other past transactions, because it helps you establish if there is a pattern. And we work with the financial advisor very closely to understand, okay, why was that withdrawal taken? Why was that withdrawal taken? And to try to craft the story if things are just not adding up. And we certainly also, for instance, if it was ACH'd or wired to a bank, we want to work with that bank to see if they also have flagged the account for concerns. So we definitely try to work with partners to piece the story together in an effort to protect the investor together.
Yeah, you make a good point on the bank. Sometimes I'm surprised at banks' ability to pull back transactions. So it really is time of the essence for sure, but banks can do things that might surprise you sometime. Tom, anything?
Right. And
yeah, go
just
ahead.
one more thing I would add is that too, we need to know this information in order to determine in the fraud area whether to file a suspicious activity report, a SAR. So that also is important to understand the background.
Tom?
So I agree with what everyone said, just clarifying some issues. We use our security department to assist in pursuing money that may have left. We're certainly not at high level of recovery, but if you can act when you're stopping the bleeding, if you can also take active steps to pursue the money at other banks, there is an international network where if security contacts security, they will at least pause the flow of funds so they can't move on. And certainly when you're trying to block transactions in the account that you are housing, you can ask for bills, ask the client to provide you a copy of the bill to confirm that the payment you're making is a legitimate payment, because we have seen that clients who are, as Ron said, totally engrossed in whatever fraudulent activity they're being victimized by, they are loath to listen to reason. And so they will start playing cat and mouse, probably at the direction of the scamster, and seeking money for other apparently legitimate transactions that don't exist. And the last thing is, welcome very much is the modification to Rule 2165 of FINRA, and also many states have legislated where we can not only stop a transaction of a disbursement of funds, but also a transaction of a security purchase or sale, which can also further protect the client, which has been a very helpful step to enable to give us more tools to use to keep clients away from the exploitation.
No doubt. We have a question from the audience that's going to lead us perfectly to our next segment in this. What steps do you take if you're dealing with a senior citizen that has disorders like Alzheimer's, dementia? And that kind of goes to Ron's point. You are dealing with somebody that has lost their fastball. To me, the best tool in the toolbox is to have some other person related to that person to talk to. There are legal avenues people can take. You can try to get a guardian appointed at state level. You can get adult protective services involved. We've had cases like that. But that's going to lead us right to the trusted contact. That's, to me, I know that if there were two things that if you all had a magic wand you'd like, it would be a trusted contact on the file and some easy way to report in to all the states. So Heather, why don't you kick us off on trusted contact?
Sure. It's kind of a no-brainer. It's an emergency contact. If you think about all the places in your life that you're asked for an emergency contact, your doctor, your gym, why not your financial professional? The trusted contacts aid us so much when we're investigating these cases. Like you said, if you're dealing with someone that has diminished capacity, you need to engage someone else to try and put the pieces together. So I think having a trusted contact on file is integral to a lot of these investigations. Otherwise, you are potentially looking in client records for beneficiaries and trying to determine if there is another avenue by which you can obtain a person to partner with to try and help the senior.
Yeah.
And if I could jump in.
Yeah, go ahead, Ron.
I just wanted to say.
Go ahead.
No, I was going to say there are a couple things here which trusted contact would be good for those who had the foresight to plan. But we're fortunate in 17 states, they will allow you to reach out to someone who's reasonably associated with the account. And then I would say your absolute fallback, and I encourage all the firms out there, is to look at your account agreement, which you should put in language that says, if we suspect fraud, or if we suspect that you may be challenged in some way, we reserve the right to slow down or pause transactions. That's not state law per se, but that at least is your contractual agreement that might give you a fallback position.
I will point out that when we did research as part of an initiative we did for commentary on the NASAA Model Act, we went to, well, some of you know this, we went to firms, and we went to states to try to figure out, are the investors out there that we're hoping to protect complaining about how these rules are being administered, the report and hold laws, stops on disbursements, stops on transactions. And what we found is that there really is no statistical significant number of people that's unhappy. Virtually everybody is happy. And ironically, or perhaps not, the people that do complain end up being the bad actors themselves that are trying to get the money out of the people we're trying to protect. New Jersey is one of those states that has the anybody reasonably associated with the account. We thought that was the right thing to do. Nancy, what do you do at your shop with trusted contact, or if there is none designated?
Well, it was a challenge because we have about 350,000 clients. We've been in business for 50 plus years. So of course, the 2165 rule, came in well past that period of time. So certainly, we added the trusted contact question in our new account form. And certainly it's, a little easier to get it going forward. It's a lot harder to get it for clients that were already clients of ours. And to be quite honest, we have, a pretty low adoption rate. And it's not for the fact that it doesn't always come up as a question. I just think either representatives might be a little hesitant to ask for it, or there are suspicions by clients as to how it would be used. That they're can be very private about their finances, and they don't want their children to know about it, or other close relatives. So they have suspicions about it.
Yeah.
I would just say that I also think that people generally, they avoid thinking about some kind of negative situation, right? Or thinking about, they underestimate the potential that they may need a trusted contact or someone on the account. And this could be, it's not just about aging, right? You could be in an accident. You could be on vacation and we can't find you. You could have abandoned property. There are other reasons to add a trusted contact to your account, not just about we have concerns about your capacity or exploitation.
Yeah, I've heard people say, you should think of it like the emergency contact you have at a dentist's office. You never hesitate to list your spouse, your child, your parent in that situation. And you're right, it could be episodic problem. It could be a chronic problem. And getting the take rate up is a big deal because most firms I speak with say that, I don't know, somewhere between 25 and 30% of the accounts will, designate a trusted contact. There is a workaround, as Ron mentioned, by putting in the client agreement. And I will mention that we heard from Ed Jones on this, and they have been able to, through some fairly simple processes, come up with a system there where with over 8 million accounts that they cover, they've got a take rate on trusted contact of 70% plus, which is extraordinary to me. They don't require anybody to sign anything in writing. They season the clientele with information about the purpose of the trusted contact. They have the assistants that work with the FAs, follow up and get engaged. They're frequently the point of contact and have great relationships with the investors. And they use things like, for example, the California wildfires. You kind of pointed out, Deb, an example, like it's a true unexpected event. When they had the California fires, they did a blitz on California and used it as an example for others. Like, this is exactly why the trusted contact exists. Tom, any thoughts?
No, I agree with all that. I mean, it's very important. It certainly is a priority of FINRA as well, and it's 2022 priorities to focus on trusted contacts, finding innovative ways to attract clients to that process, whether by communicating digitally with them, including something in statements, statement stuffer. But we all recognize that. I agree. Clients many times are reserved about letting other people know about where they have their money, how much money they have, and they are concerned that that line may be crossed. Even with the most trusted people that they know, they still want to maintain a separate, a distinction between that. So we, as with many other firms, are looking at new creative ways to press that. in addition to educating the financial advisors that they must consistently ask the clients about this. We obviously, most firms should be, do now, they should be asking this question about a trusted contact upon opening an account. And whenever there's an amendment to the client profile, that should be done. But it still has been an upward slog. It's been tough.
Yeah. So there have been a couple of questions. There was a question about how do you figure out which states have the authority to talk to somebody reasonably associated with the accounts. One place I know that you can figure that out, it's not segmented. I know the Bressler map, Bressler, Amory, and Ross has a map that has the particulars of all 50 states' laws. And Ron, I don't know if you have a list, but we can certainly circulate that after for the people participating.
I think we can. I have the lists.
Okay.
Even better.
Yeah, that's right. And then is there a periodic, the question comes, is there a periodic recertification of the trusted contact? I don't think the answer to that is yes. If they're on file as the trusted contact, they're on file as the trusted contact.
But in the 17A3, Richard, excuse me, the 17A3, every periodic assessment with the client of their profile, it should be a question that the firm asks the client to confirm that they do have this trusted contact on and this is someone they want to keep on. In case there's been a change in the relationship and they may have, the trusted contact may have fallen out of trust.
Makes sense. And the other thing I'll add, and we're going to have to move on to the next segment. By the way, any questions not answered here, we will endeavor to answer in the coming week or so. It's just not possible to answer all the questions and cover the content, but we are all committed to answer the questions. All right, so let's move on to privacy issues, Tom. And we've talked a couple of times about the tightrope walk between doing what we think is right for the client and obviously protecting the client and their privacy interests. Why don't you lead us off here?
Sure. Well, I think there's good news with regard to that, and that is, I think the law as it exists provides wide amplitude for firms who are acting in good faith with the basis for their actions based upon factual assessment can undertake to protect clients and could there are exceptions to the privacy laws. Let's drop back to make sure we're on the same page. The standard of privacy in the industry is set by the Gramm-Leach-Bliley Act and is interpreted by Regulation SP. What that says is that firms must protect clients' non-public information, and they must set the standards to the clients for what their policies are, and then permit the clients to opt out. But that law and that regulation also goes further to say, however, one exception is when a firm is seeking to protect a client from or prevent an actual or potential fraud, unauthorized transaction, or claims or other liability. Very, very broad. It was so broad that it caused confusion. And I don't know if you all remember, but in 2013, 8 federal agencies had to issue a guidance called the Interagency Guidance, which said that generally you can clearly provide information about a client's and non-public information about a client to local, state, or federal agencies. And they also indicated, which may be the precursor to the trusted contact concept, that with a client's consent, you could disclose it otherwise. What they didn't address was that you could also provide it to unaffiliated third parties in an attempt to prevent a potential or actual fraud. And moving forward, FINRA came out with guidance recently that made that clear, relying upon Reg SP, and is also bringing in the notions of 314B under the Patriot Act, which is consistent with what Nancy said about SARS, that you can, the anti-money laundering departments of the firms can communicate that way to transmit information. The bottom line is, if you want the wrap up, is that whether it be under federal statutes or regulations or under state laws, such as alluded to, 17 states do permit non-public information provided to a reasonably associated individual, such as New Jersey statute, where the firm is protecting the client against financial exploitation. And 9 states in addition have adopted language which simply point to the Gramm-Leach-Bliley law and Reg SP and don't limit it to reasonably associated, but to any third party, or they call it a non-affiliated person, to protect against actual or potential fraud. The critical issue from my perspective is we are able to communicate, whether between firms or with other entities or persons, in order to protect the client, so long as you have a palpable threat of financial exploitation that it has occurred, is occurring, or will occur in the context. And which goes back to my comment before about it's very important to keep your record keeping up to date in these situations, because this is a very high touch area. Privacy is very important right now to our society, and many regulators are looking at this issue. But in the context of the prevailing statutes, there are ways and openings to firms to protect their clients by sharing information with the appropriate entity, whether it be Adult Protective Services, a law enforcement agency, a regulator such as the Division of Securities, or other firms, or the third cousin once removed who you happen to know has an account with the firm, and the broker knows that this is person related to the client, and as they've socialized in the past, so long as you don't have information indicating that that person is associated with the fraud, in many states you can communicate to that person and ask questions about that, not violate the law. And as Ron said, from a practical perspective, I have two comments. One is, I definitely agree with him. This language should be incorporated into your client agreement so that you have the ability to have, I know there's always belts and suspenders. I'm not sure what else you'd use to keep your pants up, but you'd have state law exceptions. You would have the client consent, and you'd be able to move forward and protect the client. And the other thing is, I also noted in this privacy context, what people forget a lot of times is the FINRA helpline, the senior helpline, can be a valuable tool to communicate with if you are hesitant to communicate, if you may not be certain as to with whom you should communicate, calling them and providing them the information and letting them know that you're hesitant to step out of the privacy boundary, but could they take steps in that regard? We have received as a firm several times communication from FINRA from other firms, but FINRA was used as an intermediary. And that same concept also applies to Adult Protective Services. Pressed for the issue, we've oftentimes used Adult Protective Services to let them know after we've reported a matter that there are other people with whom APS can communicate on the situation, and not even if we are loath to do that, for whatever reason.
Yeah, I think one of the things that some close observers will notice in Tom's presentation is the word fraud. I still stress that client agreement because it's unclear if diminished capacity in the absence of fraud will allow me to pick up the phone and call Morgan Stanley and say, we have a common client. There's no fraud, but I'm very concerned about her mental capacity. I might make that call, but it's a close question, I would think.
A very good point, Ron.
Folks.
If it's embedded in the contract, you do have amplitude on that issue. And a lot of times it might say that for the protection of the client and or the firm, they permit us to either withhold the transaction. I would also include that in that language, or to communicate to a third party. And that way you would cover both ends of the spectrum, both financial exploitation as well as potential diminished capacity.
Okay, we're going to have to move on. Tom, somehow you made listening to privacy issues fun. I don't know how you did that, but good for you. Now we get to where the rubber meets the road, and that is reporting out and holding transactions. Ron, why don't you get us going on this one?
Yeah, I'll get us going and try to catch up a little bit on time, but this is where the rubber meets the road. You're going to set up those teams, but then what do you do? And there are a couple of issues that you have to figure out. In the US, we're now divided into mandatory reporting and permissive reporting states. You have to make a decision which state you're in. What I would encourage most firms is to consider yourself mandatory regardless of the underlying state law. So you're going to report to Adult Protective Services, but then there are a number of states where you have to report also to the state securities regulator. A couple of states require that you also report to law enforcement. But then as you go down the list, I think there are appropriate cases where you want to pick up the phone and call FINRA because of the nature of the underlying fraud. And beyond FINRA, I think you need to consider our federal authorities in some situations as well, particularly the elder justice coordinators who are in all 94 U.S. attorney districts, but also Secret Service or the U.S. Postal Inspector. So making the report of elder financial abuse to Adult Protective Services many times just begins the conversation. And then the question of who makes that report. We all said centralized, but absolutely make it clear. The financial advisor on the scene almost never, ever should be the person picking up the phone and calling Adult Protective Services, save for the situation where they should call 911 if there's physical or in front of them they see ongoing harm, and that could be worse if they didn't call law enforcement to step in immediately. But you want the centralized team making those reports, doing the background work and what have you. Again, even if you're a smaller firm, coach somebody up and let that be the person that everyone knows to go to when these situations arise, if for no other reason to get that second set of eyes on the situation.
Yeah,
I wanted to see if some others. Yeah, go ahead.
Yeah, there's no doubt the rules contemplate that there's going to be a seasoned person at the helm making the decision about whether they've got a fact pattern on their hands that warrants a report out. They don't want novices mucking around in this machine. Deb, anything to add on, when the trigger comes to report out?
Yeah, so I would just add, I think it was great that Ron listed other sources, right? So we all know this is state by state legislation. So every state handles this differently. So it's important for you to realize if you call Adult Protective Services and they're going to screen out your case because it doesn't meet their criteria, that you have another avenue, right? That you can call a regulator, even if you're not mandated, or you can call the Elder Justice Coordinator, or you might want to call the local sheriff. It all is really dependent and state by state. And I think over time we have learned what are our better avenues. I mean, if you have a client that's being exploited and you have concerns that the bad actor is truly a bad person, I'm not sure you want to send an Adult Protective Service caseworker out there, right? You want to understand what's going on first and then figure out who is best to contact with regards to assisting and going out there. And like Ron said, could be more than one agency. So don't give up. If you're falling, if you're getting your door, the door closed on you, keep going. There's a lot of resources out there.
Yeah. And again, I would encourage people, I know we take those phone calls and you're not alone, whatever the size of the firm. We will try to help you figure it out. Heather, you've heard a lot, but anything to add on figuring out how and when to report?
No, I think, obviously the jurisdiction's guidelines, but, as Ron and Debbie said, knowing that there's a wide variety of agencies that can assist you. And sometimes, it can be a challenge to engage. And I think part of getting someone to take the case, whether it's Adult Protective Services, is also your influencing style. I feel that that's been really important. Being able to state your case clearly and know your audience, because Adult Protective Services may not have the financial training that we do, and we may not see things in the same way. So I think it's really important to, again, know your audience, or you talk to a regulator, what your ask is, and be clear and concise in order to hopefully get the outcome that you want.
Yeah, you make a good point. I remember somebody saying, speak APS speak, don't speak financial advisor speak. And that's just kind of dumbing it down, because APS agencies around the country didn't grow up dealing with financial transactions. They grew up around the country taking care of people's literal physical safety, food health issues, abuse issues. And now on top of all of that, they're being asked to help intervene in instances where state law requires a report to them. Nancy, anything to add on this?
Just quickly, I'd say that, again, the financial advisor often is the one that is the boots on the ground as far as knowing what is happening in this situation. So oftentimes APS will want to speak to the financial advisor as what they call collateral, someone that had the direct communication with the person that is potentially being exploited. So we definitely work together in getting them prepared for that type of conversation.
I think I will want to say one thing
Go ahead.
with Nancy's talking about that leads to a challenge. It's not a whole lot we can do, but we should try to do better. We do have a number of agencies, a couple of law enforcement that go out to the perpetrator many times and say, ABC financial firm says you're working your mom over. That's not very helpful because quickly they come back into the branch and want to have a showdown with whomever may have handled the situation. So it would be great if we get that help, but more importantly, build a protocol for your folks, your frontline people, so that they know what to do when this happens, because it will happen. And you don't want to lie to them and say, we didn't report. You can come up with the appropriate phrasing that these are confidential. I can't neither admit nor deny. And then make sure you tell them to call legal as soon as possible.
Yeah, Ron, I'm with you on this. We've had discussions about this in our unit. What you want is for law enforcement to be in this mode of, I'll say, discovery as opposed to accusation. The accusations, and much like, frankly, APS, most law enforcement, the likely law enforcement person, talk about local town police, didn't grow up trying to decipher, what's going on with an exploitive financial transaction. So, partnering with them, talking to them, that's something we're working on doing. Totally agree. Tom, anything more?
Yeah, for those that are less familiar with what we're talking about, I just wanted to make sure there's a clear line of distinction. We've been talking about reporting the observance of financial exploitation. What we're not reporting about, which is a totally separate report, is when you use the report and hold laws and you stop a transaction, which under FINRA rules can now be both a disbursement of funds as well as a securities transit purchase or sale. And under many state laws, I think it's roughly 30 or so, they allow you to do the same under that legislation. That's a separate report, which has to be also presented to typically the Division of Securities and many times APS. And then you're required to do that in a very short window of time and potentially have to provide updates of your investigation while the hold is pending so that the Securities Division can be aware of what is transpiring. So that's a completely different reporting model, but comes back to what we've all talked about, which is experience and centralization is very important. Whoever is providing these reports has to choose their words and their communications carefully to make sure that they apprise the Securities Division of what needs to be apprised, but don't make statements which they can't back up. We're very focused on making sure that what we communicate is founded in fact, and that we're not interpreting facts and providing editorialization of what we see has occurred. Very important.
So we have a couple questions from the audience. Anybody field this as they see? What has been your experience regarding APS state authorities taking action on a report of suspected abuse? Anybody on that?
Vary state by state. Go ahead, Tom.
I would say it's just Ron and I are on the same page. It's a state by state issue. It's even within the state. It's a county by county issue. And it depends upon a lot of factors, and alluding back to what I don't remember which my co-panelist said this before, but it's how you speak to and how you present the matter to APS. To my team, we talk about scripting what we're going to say to make sure we accentuate the positive, eliminate the negative, and don't mess with Mr. In between. I mean, you want to be able to provide information which is going to attract APS to handle the circumstance. If we are flooded, I can't imagine how they are, because they must be inundated with matters coming to attention, because as you allude to, Richard, it's not just financial matters. They're handling a whole huge case file of other types of matters that they traditionally have handled. So we are in addition to what they're doing. So we have to make sure that we present the matter efficiently, truthfully, but also that captures their attention on the matter, because it runs the gap. Some states, one might perceive as better than others, but I think the gamut is they're working very hard to protect the population, and many of whom are amongst our clients.
We have one more question, and I think we're going to have to pivot to the next topic. We have a little more time here. The question comes, a client you are concerned about leaves your firm. Is there any effort made to pass on the information to the next firm? Is that allowed?
I think that, yeah, go ahead, speak, Nancy.
Yeah, I can speak that I've done that. I've done that with people on this call.
Yeah.
So, yeah, we don't want to, now granted, a lot of firms would just say, it's not my problem anymore, right? But I think for us to help each other, sharing that information and what we've experienced with the client so that the next firm is not blindsided by it is really important.
Yeah, I would agree with Nancy. We try to help whenever we can. And, there are circumstances, unfortunately, where if we can't assist the client and they opt to leave the firm or we opt to exit the client, we don't want to feel like we're just moving the problem, right? We're not just pushing it down the road, right? We're trying to help, right? We're trying to help them not be a victim anymore or get someone involved, things like that. So yeah, we absolutely do reach out.
Yeah, I'll say it feels like you should, doesn't it? It feels like you should. We have to move on to the next topic. Now we are on the client investor handling issues. Obviously important. Nancy, why don't you get us going on this, please?
Yeah, I mean, ultimately, what is happening is the client is experiencing a violation of trust, right? No matter if it's a relative, a romance scam, whatever it is, this is an issue of a trust violation. And they're not going to come up and say, oh, thank you so much for letting me know that I was scammed and they took all my money. They are coming from a defensive position because oftentimes they have believed what is being told to them hook, line, and sinker. And so you need to empathize with them and not treat them like they're stupid or an idiot for falling for this scam, even though it might be a scam that we, have heard over and over and again. They have to be treated as an individual. And also, as it comes from the point of a diminished capacity scenario, you don't want to make assumptions that just because they're a certain age, that, well, of course, they've lost their capacity. That's also not always the case. So you definitely need to treat them as individual cases and determine how you're going to handle it from that point of view.
Tom, what would you say here?
I would definitely agree. One technique we've often tried to use to make sure that the client is cognizant of the fact that she or he is not alone, that they're one of many victims. We try and provide information that's publicly available on Google or whatever server your search engine you use to show the evidence of scams that are occurring. But as Nancy said, a lot of times these are matters that go to the heart. People are lonely. It was made worse by the pandemic when people were quarantined in their homes. And whatever people were able to say on Facebook or other methods of social media where they transfix the client on a relation that doesn't really exist and convince them to part with their money, those people believe it. No matter how we may sit back and say that's preposterous, they believe it. So you have to make sure that they understand that you're supporting them. It's a little bit of tough love. I found that one of the best things is to speak to the advisor, make sure we understand what the client's profile is before we communicate to the client. Typically, to permit the broker some separation, we don't have the broker necessarily on the call unless they think it's more appropriate. But a member of the management team will reach out and speak to the client. And it's very important, is it, not to prejudge and make sure you let the client know that it's a difficult situation, but we're here for them.
Yeah.
Sometimes we've been able, if we can find specifics about the perpetrator, and that you can sometimes do that. They tell you that say he's a doctor from XYZ locale. We can confirm there's no doctor from that. It has helped pave the way a bit too.
Yeah. I mean, I actually think I've talked to some of you about this, but I mean, you all have been in situations where the very scam being perpetrated on the investor has been reported in the news, and it's virtually identical. And you send them an article or reporting on it, and this goes to Melanie's point about how it can be heartbreaking, and you know what's going on, and you figure they should know, but that's, rational thinking. Heather, anything to add here on investor handling?
Yeah, I think for me, the approach that I have taken, and I kind of ask my team to take, is to, remember that, and use the term that the client has been victimized. They haven't been scammed. They're a victim of a crime, and I think it's important to have that, use that language. And I agree that there are times where it is very beneficial, depending on the relationship, to have the advisor on the call with me or with one of the analysts on my team while you're asking strangers a lot of nosy questions. Because I think it does help, especially with that rapport. Otherwise, we do try and keep our units separate, especially when we're making decisions about transaction holds. But I do think that having the advisor on can be really beneficial in these conversations.
Yeah. So the question comes, it's really not part of what we intended to cover. I have talked about this, and I know others have as well. How about instances where the FA has diminished capacity? That's kind of not in the wheelhouse for what I'll direct the asker of the question, where to go on that, but it's definitely a question that needs some attention. Deb, anything further on investor handling?
I would just say that, more often than not, they're embarrassed, right? And they're feeling, you don't have to be diminished to be exploited or a victim of a scam, right? Most of us have clicked on a bad link, right? You're not paying attention. You're in a hurry. Romance scam, I'll separate, because I think that's a completely different animal. I think there's a lot of brainwashing going on there. It's love bombing. It's constant attention. And even when we've spoken to clients who have been victims, when they've realized they've been a victim, even after that, they still reference it like a breakup, right? Like they were still in that relationship because there was a lot of feeling and a lot of emotion going on there. And, these scammers have a lot of time to invest in that. So, sometimes when we call out to outside agencies, we try to say, this is what harmed the client. This is what happened to harm the client. This is what we would like you to do. Because sometimes when we're speaking to them on the phone, we're not going to get through because immediately we're going to hang up and the scammer's going to be right there again. But sometimes sending someone out there like APS, like someone in uniform, right? Someone they trust out there to say it to them again, sometimes makes a big difference.
We've definitely seen that. I mean, we have an investigator now retired who firmly believed that nothing really helps like somebody with authority, actual authority, knocking on the door and making a compassionate visit. Nancy, is there anything more you want to cover in this segment before we push along?
No, I think I think everything's been covered rather well. Thank you.
All right, we actually are a little bit ahead of schedule, so we can spend some time now on, I think, a critical issue, training. Before we get to it, I'm just going to plug the joint SEC FINRA NASA training module that was put out there. I don't know, it's in the last fiscal quarter or two. It's ready-made. Firms can take it and modify it for their own purposes. It doesn't take a ton of time. The other thing I'd point out, everybody may not know about, is AARP's bank safe training. It is a fantastic tool, and the stats that show the impact of the bank safe training on people, the bank tellers, and a lot of this money is going out through bank tellers, is nothing short of extraordinary, in exchange, mind you, for like an hour or two worth of training. So Heather, this is your segment. Why don't you get us going on training?
Sure. It's kind of an area that I'm pretty passionate about. I think with respect to financial exploitation and diminished capacity, I think that it's more of a training, the approach is more of a training program and not just a training session. While the core requirements like red flags and escalations are important to reinforce and to train on, I think it needs to be an ongoing series of discussions and different types of targeted trainings that are tailored for the audience. For example, we've had a lot of the questions that I get from advisors are, what happens when I make a referral? What will happen next? So we have done some panels with advisors that have actually gone through cases with us, and we've presented those at our conferences, and they've been very, very well received.
Definitely fact patterns that people can think about and learn from that are real or even, made up. I mean, that's how people go through law school and other education. Deb, any thoughts here?
Yeah, so here at Fidelity, we try to put this in any training we can, right? So of course we have it in our AML training, we have it in annual training, and last year we decided to spread that out. So now we're doing quarterly training on this, just to kind of show, have a refresher. Instead of just getting it all once a year, every quarter we might target something like, this is what scams look like, or this is what exploitation, some of the cases that we have seen, give different scenarios, things like that. I mean, obviously we have World Elder Abuse Awareness Day coming up in June, so we're going to do a bigger campaign in that time frame. But we do think it's important that everybody's going to be affected by it, right? So like Heather said, you kind of want to target it a little bit. So when we do the frontline reps, we're going to want to talk about the red flags, right? When we train the individuals in the dedicated groups, we're going to want to talk about how to speak with investors, how to train our advisors platform, because their relationship is a little bit different than our retail brand, our retail business line. So it is really audience driven, on some of these trainings, although everybody should obviously be trained on the red flags and warning signs and things like that. And, it's unfortunate that if anyone has ever, had the experience of someone with Alzheimer's or diminished capacity, oftentimes it is your financial person that identifies it first, right? It's not the family member. They're sometimes too close. They don't want to recognize it. They don't want to see it, right? Oftentimes it is really someone, your advisor or your banker or someone in that space.
Yeah, there's no doubt that, I think of the family as first, but you're right. If it's gradual and people are kind of in denial, they won't run and recognize it. Whereas, advisors and firms know that they need to have clear-eyed people on the other end of the phone authorizing transactions. And they may be the first person to see it. Ron, what do you do?
No, I agree with that. And one of the things I would say in training, and I know we're always on tight time limits, but don't ignore the benefit of the war story. Hearing from the advisors about their actual experiences. I saw in the chat earlier, somebody wanted to know what to do with the person reluctant to write a will. And one advisor said that what I use is saying, you're either going to write the will or the government's going to write the will. You throw government out as the boogeyman. Folks, not every time, but many times they'll anything but having the government take over.
Yeah, for sure. Nancy?
One other thing I would add is don't also forget that giving some, not training, but education to clients, dripping, recent scams or ways that they can protect themselves is also important. Especially, I think most of our firms probably have a social media presence where you can have your marketing department work with them to post articles on things of this nature. So don't forget the client-facing articles that could also help in helping them identify a scam that might come across.
Yeah, and I would just say there are great resources out there. The FTC has some really great resources on all types of scams that they can look at. AARP does a ton of scam alerts you can sign up for. So I think pointing our clients in the right direction with those resources and educating them is obviously the best thing that we can do. It's hard to get it all out there, I think. And they can become advocates as well. When I've spoken with senior groups and they're embarrassed to talk about that they've been a victim of a scam or an exploitation, I always say, tell everybody how it went down. Tell everybody, you're a victim and how it worked. You could be helping somebody else.
Yeah, Tom, I want to turn to you, but there's no doubt. I mean, I've heard a lot actually lately about the, blame the victim stuff. And there's a reason why these episodes are so seriously underreported. I've heard everything from 1 in 5 to 1 in 7 to 1 in 44. And it's because, like, if my mother had done it, years ago when she was still with us, probably my first reaction would have been, Mom, what are you doing here? And so parents want to avoid that confrontation. And they know what not to say, much like, frankly, kids know what not to say to their parents. Tom, anything you'd add here?
The nice part of going last is you can say, I agree with everything everybody else has said, because I do. But I would add, though, that when you're talking about the training and the educational components, it's not just to the clients, but it's also to people who are clients, not concerned about their own situation, but about people they may love in their sphere of influence. So we try and direct some education to what to do when one of your relatives or friends succumbs to a fraud or starts suffering from some cognitive difficulty. So they don't focus on themselves, they focus on the people around them. And that way, hopefully, they'll internalize the message from when it occurs to them. The other element I would just say is the training is important, and very important, not just to have war stories, as Ron alluded to, but also to the people who are creating the training need to be the people, the boots on the ground. They have to be the ones to give the insights as to what is more significant, what is less significant, where to focus and not. If the training is occurring from back office, from home office, and doesn't have that input, it will not be as effective as it is with, and that comes back to the war story reference, the real-time references to what's happening out there. I think it's a novel idea to do it quarterly as opposed to do it annually. But the bottom line is it has to be comprehensive, it has to be mandatory, and everyone should take it.
There's no doubt, and it doesn't take a ton of time. It really doesn't take that much time. Right. Look, so we had a comment from one of the listeners saying, I have found that many financial professionals are totally shocked at the percentage of times that the exploiter is actually the caretaker family member. And that kind of goes to what I said in my opening remarks. People that are not able to make sound financial decisions are exploited by, there's a couple of silos. The immediate family, it's a big percentage of the time. And then you have the romance scammers, the computer, Microsoft people that want to help you with your computer, international organized crime. And then, in this space, the financial advisors and the firms usually are not the culprits. And by the way, when they are, you guys are calling me and saying, something went wrong. You partner, and if it's bad conduct, it's bad conduct. So, look, that's about as good a way to end it. I will mention that we all did discuss the idea of what it's like to work in this space, vicarious trauma and compassion fatigue. And we decided that it didn't make sense to address that here, but it should be addressed in a go forward program, which we will do. I cannot thank you all enough for appearing, preparing, and being so crisp on this phone call. And a special shout out, you're all great, but Tom, you made privacy issues fun. I don't know how you did it. So what we're going to do now, I'm going to sign off with Tom and Heather and Nancy. We're going to keep Debbie and Ron Long, and James, if you'd be good enough, I'd like to bring in Maren Gibson. Maren, you are SIFMA's Managing Director and Associate General Counsel, State Government Relations. Thank you so much for being here with us.
Thank you. Thanks, Rich, to you and to all the state securities regulators and to NASAA for hosting the webcast today. We have partnered with state securities regulators for many years, working on policy and practice solutions to benefit senior investors. But the state securities regulators are an absolute key to the success of Helpful.
Well, that's good of you to mention. I know that this is something that has been near and dear to your heart for about a decade now, Maren. and you know, to the others on this segment as well. We all know that dealing with reports in different states is, you know, frankly, as different as every state can be culturally. You know, we have a very big nation, obviously, and then you've got Canada on top of that. We're not covering Canada and its 9 provinces. But, you know, and even frankly, in New Jersey, just, you know, from my own experience, it really does depend on what county, you know, the reaction you're going to get. Like, we've got a guy, as we say in Jersey, up in Bergen County, who's just an absolute ace when we have a problem. And he's as good as anybody I've met. And then, you know, there are other counties who just don't get that many reports or haven't had the exposure or whatever. So, you know, it's in that context that we wanted to talk with you 3 about, you know, what are the challenges, what are the headwinds, and, you know, again, I know I mentioned this earlier. I know that everyone wants a trusted contact on file. And the other thing you want is an easy way to make a report so you don't use your unit's precious time finding where to report and how to report, as instead you want to be making the report and acting on the report. So Maren, why don't you talk a little bit about that context and the possibility of a solution with a centralized reporting system?
Sure, thanks. So Debbie touched on this and as did Ron, but broker-dealers in the securities industry in general have made great strides over the past 10 plus years in the recognition and training on identification of senior financial exploitation red flags, the internal coordination and investigation of suspected senior financial exploitation has developed really, really well, very effective. A bunch of firms have developed the centralized teams that we heard about in the first panel. But once a suspicion is formed that the senior investor is being defrauded or is at risk, a report is ready to be made. And that is where the process really slows down and becomes very complicated. Rich, you mentioned the county by county aspect. That requires a jurisdiction determination that can be really complex. There's, you know, the local reporting, the method of reporting varies more than you'd think by state and locality. The report forms and formats vary. And so that part of the process in us addressing senior financial exploitation has all of the barriers that it's had for years. It hasn't really improved like all of the other elements. So we really need to figure out a way to eliminate friction from that part of the process. And we developed a plan. Anybody who's worked on this may have heard me and Ron talking about it sometime over the past decade, all the time. To streamline and centralize reporting. We call it single portal reporting. Oh, and let me note that the CLE verification code has just popped up, 504230.
Now you're really working for NASA, Maren.
I know.
Very graceful pivot there. That was nice. So go ahead, go on. Thank you.
We're trying to eliminate the friction. We came up with this single portal reporting plan. And SIFMA unfunded, but we joined with the National Adult Protective Services Association and our great tech partner EverSafe and representatives from 2 universities to propose a pilot single portal reporting platform. And in 2018, it was approved by the US Department of Justice. So they accepted it and they agreed to fund the development and the piloting of the proposal. The platform was subsequently named Helpful, helping the vulnerable. Great name, but you realize how many times in the conversation on senior financial exploitation you would use the word helpful. So we had that going before COVID, and it is helpful is a secure, unified reporting portal. It connects financial firms, adult protective services, state securities regulators, the U.S. Postal Inspector General, which is great because that's a 50 state coverage. And more. It can be law enforcement in some cases. So you want me to just go into the process, Rich?
Yeah, why not? I mean, look, I've seen the demonstration of the product, and it is important to keep in mind this is a pilot program and a possible solution, but it's an idea that can save, I think, investors' lives. So go ahead, Maren.
Yeah, that's exactly right. And honestly, in senior financial exploitation solutions generally, innovation has been key, and it's come from a lot of different places. So this is one idea. So a firm would create in a standard format report a new referral in the helpful dashboard. That referral is securely and immediately sent to the agency users, the Adult Protective Services, State Securities Regulator, and the U.S. Postal Inspector General, maybe more.
Simultaneously, important to note.
In real time.
One button push, it goes to all three.
Correct. Once the referral is accepted, then the case is assigned to the Adult Protective Services Agency or the investigating agency, which could be a state securities regulator. The agencies can add notes, they can ask questions. There's two-way secure messaging. They can request supporting documents. They can attach a subpoena if required for those supporting documents. And then the documents can come back through the secure portal. They can view an audit trail, which has been really helpful. They can even search related cases now if they're trying to see if the same perpetrator is responsible for a bunch of cases.
I find that to be incredibly useful. We do that through spreadsheeting, but it's a good feature.
Yeah. And let me just note here that once the financial firm makes the report, it's all of the investigating agencies that can see all the data. The financial firm cannot see that once it's made. It is secure and confidential among the investigating agencies.
Right.
So we have right now 3 states that have both their state securities regulator and their adult protective services on. We have 1 state and another coming that has their adult protective services only right now, but it will develop. And we actually had 1 county that also piloted and implemented the program in California. So,
you know, it's funny that you mentioned that because I saw something on LinkedIn today about somebody out in California talking about, you know, the sadness of these problems, and that San Francisco had this system, and that it was a tool that he felt, he was a state regulator, that he felt, or maybe not, well, it doesn't matter. The system was working in a way that he thought it was helping to, you know, stop the bleeding, to use Deb's term.
Yeah, that's interesting. You know, the thing is, in every single issue of senior protection, whether it's investors or physical harm, or whatever, we all know time is of the essence. So
Right.
this is one solution that can really save a lot of that time.
No doubt. Let me just turn for a second to Ron and Debbie, just to get it from the financial services side. I mean, we will have our own concerns, APS and state regulators, obviously, but firms can't just sign on to the system without vetting it and making sure that, you know, to Tom's privacy segment, that data is properly being handled. So Ron, Deb, I know both of your firms have signed on. I think there are either 24 or 26 firms total. By the way, it's a start, but there are 3,500 registered broker dealers in the country. Ron, I actually don't know who signed on first, Fidelity or Wells, but both of you will have a chance to talk. Ron, what did you do to get comfortable with this notion of centralized reporting through Helpful?
Sure, and to be clear, we're not on today because we've expanded. And this, I just want to point out to the audience, is one of the challenges. Your technology folks always get nervous when you ask them to make big changes. So we had started small in the brokerage part of the firm. And it was that comfort level of knowing if we ever got to one-stop centralized reporting, that's a benefit to the firms, it's a benefit to the customers, a benefit to APS and all the regulators. This concept of having to have a Bible, literally, to decide if this is a firm where you make a phone call, is this a firm that takes an email, a fax, just about everything minus smoke signals, I think, or variations of how you could report. And Marin hinted at it, but a big benefit is this information is now all, for the first time, would be in one place where anonymized, we can get some true statistics. You go out today to ask what are the stats on elder financial abuse, and you'll find things all over the place. Is it 3 billion a year? Is it 44 billion? We would use helpful and it would tell us.
Yeah, you're right about the data. I mean, I'm in discussions with several agencies and some researchers and trying to figure out the actual size of the problem in dollars, direct costs. And the biggest issue is getting good data that can be merged for analysis. So I agree this would help with that as well. Deb, how did Fidelity get comfortable with the program?
So it was a little challenging in the beginning, right? Because it's data, right? It's our data, it's our client data. And so you will have to jump through a couple of hoops. If you are considering, getting helpful signed on, there will be, tech people that will want to know how it works, risk people that will want to know how it works, right? I'm not going to tell you it was easy. It wasn't easy, but it was worth it because it is so much more efficient from our perspective, and I would assume from APS and the regulator's perspective, because you are in one place, you can upload documents, you can print your report for your record keeping, you can communicate through the tool. So if there's a question that needs to be asked, you're not going back and forth with phone calls, especially with time changes. If you have someone on the West Coast, you're on the East Coast. So much more efficient. We have done some testing on how long some of these referrals can take us to make. And in some states, we're up to an hour of getting someone on the phone, of filling out a specific form and then faxing it in or emailing it to someone, getting someone to call you back, things like that. So we definitely think this is beneficial to us, to our customers, and just for the whole flow. It's just a much more efficient approach. And we know it's going to the right place. We know we're clicking a button. It's going to where it needs to go for that state, because every state is different. We know it's going to the right place.
By the way, one of the listeners asked if we could provide the website for helpful. It's www.eversafe.com/helpful with a VUL at the end. Maren, you want to follow on our friend's comments about the system?
I think that's exactly right. I mean, we wish that there weren't so many cases, but an hour, for instance, for each case would be far too many, and you're not able to effectively source them and get them made. So I think that this just has so many benefits for streamlining. It's, I think the biggest thing is the increase in collaboration and coordination. I think even one of the benefits that wasn't necessarily apparent on paper was just getting the people from the different agencies and states to get used to working with each other. They may not have known each other before, and now they have kind of an effective working relationship. So yeah, definitely saves time. There's collaboration, coordination, and Ron's point on data is critical, because we all know that the data is not great in here. Privacy is a big part of that. But getting better data is useful for everybody. The firms might be able to see, what scams or frauds or caregiver even issues are really starting to take center stage. The agencies can help support requests for resource allocation, increase in resource, et cetera. So I think that we're really hopeful this starts to give out some useful data.
And one thing I will add too
ahead,
is ideally this should be done by the industry voluntarily. But since we gave the disclaimer earlier, I will say if it takes federal legislation to have the agencies, have the firms all find this system, which does work, I think we should consider federal legislation. Because if we keep doing state by state, county by county, it'll be 21, 22 before we get a system that works.
Yeah, and by the way, and Maren implied this, and you two did as well. I mean, we're dealing with the caseload we're dealing with in 2022.
That's a good point.
I mean, is there any doubt that the numbers are going to go up? There's just no doubt. And so anything that can be done to redirect time that would be spent on the process of reporting to the solution finding in the space is, it's simple elegance, frankly. I see we have Heather and Tom and Nancy still here, but not on camera. Do you guys mind coming back on stage with us? Because I'd like to get input from you three as well. And by the way, thanks Deb and Ron and Maren for kind of setting the table. We have about 5 minutes, and I'd like to, just hear from you what you think. Nancy?
Well, we have maybe 30 to 40 cases a year, right? So compared to, again, Debbie and Ron and others, that's probably a drop in the bucket on the number of cases that you deal with in a year. So from the helpful standpoint, if there are only a few agencies that are signed on to use this, I don't know if that makes a lot of sense for a firm of our size to sign on. So do you have any thoughts on that, Maren or Ron or Debbie?
Maren, what would you say to that? I mean, if you've got 30 reports a year and, all states on board, and this kind of makes Ron's point about federal legislation, doesn't it? Is it worth the candle to go through the process of vetting it and getting comfortable with it for a smaller firm like Nancy's?
I think it's 100% worth it. I think that the onboarding can be a little simpler. The tech is proven, the privacy is proven. So it can be worked out pretty directly. Actually, the onboarding for some firms has been pretty quick. I think, we have two very, very large firm examples. And I'm going to use that as a nice segue to say, if your state or financial firm is interested in learning more about Helpful, to touch base with me, mgibson@sifma.org, and I will put you in touch with the people who can do that. But I do think it is worth it.
And I would just add to that Nancy, I mean, it's certainly, are most of my cases in these select few states? No. But I felt like if I started down this road now, because I am very hopeful this is going to be nationwide, that I've already done the hard part, right? I've already jumped through the tech hoops and I've done all those things so that I'm not starting at square one when this spreads out, to multiple states, especially states where we do have a lot of cases that Maren has promised that she's going to get on board for.
And the only thing I would add, Nancy, when you have that one of the 30 cases that's very intensive, wouldn't it be fun to be able to just email back and forth the questions, getting the answers, or pulling up the records when evil attorney shows up and says, how could you have possibly done this? You'd have a quick, easy resource to get all of that information.
Heather, any thoughts on this?
Yeah, I've started looking at it. We haven't signed up yet, but we have been trending upwards. I think we're going to see 200 cases this year by my estimates. So I think it makes sense, to Debbie's point, to kind of jump on the bandwagon now. And, as things trend upwards, and even though you may not be reporting in those specific states, I think, as more states come on board, then you'll already be, hopefully ramped up. But I agree, anything, selfishly that can save time, because the referral process can be long and, arduous at times. So anything to streamline that, I think is fantastic.
All right, Tom, I'm going to give you something I never give you in person when we see each other, and that's the last word.
Any of you here? Let me move my tie.
Yeah, I do see you don't have a tie on.
For the regulator.
Just for the audience, he was razzing me for not wearing a tie, and look where you are now. So any thoughts here, Tom?
So I think that it could certainly helpful to be very beneficial. I've known Liz Lowy for a long time, was with Helpful, and it's a good organization, strong organization. So just as one agreed, it needs to be rolled out to more states to have it provide the efficiency, the potential it has, but we need, and the reality will be when it gets rolled out to many more states, be beneficial.
All right, all of you, tremendous presentation. Thank you for all the time in the run-up, for appearing, and for doing what you do. Next segment we'll do was going to be in the fall. We're going to take a summer vacation on this program, but the next one will feature state, federal, FINRA regulators, and APS agencies talking about it from their point of view, including the compassion fatigue and vicarious trauma. On behalf of Melanie, on behalf of NASAA, corporate office, and all the others who helped put this together, thank you so much and have a great afternoon.